What are proffer meetings like? Well, typically you get brought to either the courthouse or to the U.S. Attorney's office if you're in custody, or your attorney walks in with you through the front doors of the U.S. Attorney's office or the agency that's prosecuting you. And then you sit in a conference room across the table from federal law enforcement. There's usually the agents. They have the prosecutor, whether it's an AUSA or an ADA, or maybe even the Assistant Attorney General, and you first go over what's called a proffer agreement. Proffer agreement sets forth the rules of the meeting, the rules of engagement, and essentially, while proffer agreements differ district to district, they pretty much say the same thing. You could still be prosecuted for this case. The information that you give can be used against you to develop other leads. If you lie to them, you may be prosecuted for making a false statement, or obstruction of governmental administration, or perjury, and you have an obligation to be truthful, and the information that you give to the prosecutors will be used for them to make decisions on the case. So usually you get the proffer agreement ahead of time. Your lawyer goes over the proffer agreement with you ahead of time. The prosecutor also makes sure that they explain it to you. They generally read verbatim. They paraphrase some of the provisions to make it easier to understand, because some language in that agreement is like a foreign language. And then they have you sign, the lawyer signs, the agent signs as a witness, and the prosecutor signs. In the first proffer meeting is they have you talk about your criminal involvement. They have you talk about your past criminal conduct. They don't care about other people in that first meeting, because they're sussing out who you are like as a person and whether or not they want to work with you. If you knock it out of the park in that first meeting, there's then subsequent meetings where you do talk about the involvement of others and what you know, and you're hoping to get yourself a plea pursuant to a cooperation agreement. You're hoping to get yourself that 5K1 at sentencing, and the prosecutor is hoping to shore up their other cases or develop other investigations based on the information you give to them. I'm here to tell you, and maybe I'm the exception and not the rule here, cooperation generally goes sideways, meaning it doesn't work out. Either the prosecutor says the client was not truthful, or the client's minimizing, or the prosecutor says the information does not rise to the level of substantial assistance, or the prosecutor says client's conduct is unbecoming of a cooperator. And that may happen, and if that happens, everything kind of terminates, and then you're back to square one, except they have all the statements that you've made, and you winning at trial just becomes that much harder. You could be in the minority of people that end up with plea pursuant to a cooperation agreement that do get that 5K1, and ultimately you're at the government's mercy about how often you're coming in, and how many times you're coming in, and how often you're talking to them. And if all of this pans out, the prosecutor will go to sentencing, and the prosecutor at sentencing will write to the judge what your cooperation was, what your information was, what your involvement was, and the judge will take all of that into consideration.